You ought to be following, as the rest of the audience knows, the McCarthy Report. It's the best podcast available, the McCarthy Report, on all the trials of Donald Trump and all the different issues, because it is hosted by Rich Lowry, who's a very great pro, and then my guest, Andrew McCarthy, former prosecutor in the Southern District of New York, author of many books, including The Grand Jihad, the man who put the blind sheikh behind bars after the first World Trade Center attack. Andy, good morning. Thank you for joining me.
Hugh, thanks so much for having me. Good morning, and thanks for the kind words about the podcast.
It's a fabulous, I don't know how Rich does it because he's not a lawyer, but he asks all these great questions. Maybe that's the secret, no inside baseball, because Rich isn't a lawyer, but it really does flow. How many times a week are you doing it? Just once a week?
We do it once a week. You know, Rich also has a great podcast called The Editors on NR, which he does twice a week, so he's got a full plate. And I seem to be a little bit busy these days. So.
Oh, you're so kind to carve out time for me. Andy, I want to start by asking you, when someone looks up at their television and they see a, quote, legal expert, how do you rank them? What do you want to know about a legal expert when they're purporting to have an opinion on one of the Trump trials?
If they call it down the middle, you know, I think if it's like somebody who these cases are so politicized, and the great temptation for people, especially as they get more remote from trial work, and I've been out of trial work for, 20 years now, it becomes a lot easier if you don't really try to discipline yourself, I think, to go with your politics instead of, what your legally trained eye tells you. And I think if we're doing this right, then if you're really trying to call it down the middle, then sometimes your legal view of things, as Justice Scalia noted any number of times, your view of how the law works is not always consistent with your politics. And if you find that your legal analysis is also always conveniently happens to track your legal preference, your political preference, then you're probably not doing it right.
Amen. And I always tell people, I am the last guy to ask about criminal process. I took Crim Pro from Jerry Israel in 1983. I've defended exactly one criminal defendant. I didn't know where to stand in the courtroom. It was chaos. There were people in orange jumpsuits everywhere. And the prosecutor helped me out, get him diverted. It was a kid, the son of a friend of mine. And I got him diverted into a drug diversion program. And then I've served as a juror once in a 3-strike carjacking, assault, a battery case that was a drug dealer. It was pretty interesting. It was a hung jury. That's my whole experience. Andy, how long were you a prosecutor in the Southern District of New York for?
I was 20 years, almost 20 years exactly a prosecutor, and for a number of years before that, deputy marshal in the witness security program.
How many trials did you do in those 20 years, criminal trials?
Oh, I don't know. When I started it was before the sentencing guidelines, which really kind of dried up a lot of trial work. So my first year, I had 11 trials, I think. But most of them were really short. I also had the opportunity to be on what I think is still the longest federal criminal trial in history, the Pizza Connection case, which was a 17-month trial against an international mafia group. And the blind sheikh trial took 9 months. And day by day, nobody really knew we were on trial, because at the exact same time we were on trial, there was this little thing going on out in California called the Orenthal James Simpson case.
Yeah, I covered that as a reporter, but I want to stay on the blind sheikh for a second. After the blind sheikh, you wrote a great book called The Great Jihad. And it just keeps coming to mind in the course of these encampments on campuses. They look organized, Andy. I heard you talking briefly about the Holy Land trial with Rich Lowry. Would you remind people that the international extremist Islamist movement is not uncoordinated? It is not a bunch of amateurs giving away stuff over the internet. They are very well organized.
No, to the contrary, I think the Muslim Brotherhood is probably the most successful ideological movement of the last century. their tentacles in the United States are very broad, and I think the most important building block of their infrastructure was the Muslim Students Associations, which were really established by Saeed Qutb himself. He was the second and arguably the most important leader of the Muslim Brotherhood, put to death in Egypt in the 1960s. But they established these chapters in the Midwest beginning in the mid-60s. And after, 2 or 3 generations, you have, on many campuses throughout the United States and Canada, you have 3, 4, 5 chapters of the Muslim Students Association, which is really an anti-American, counter-constitutional kind of fundamentalist, Sharia supremacist ideology with a leftward bent. It colludes very well with radical left political ideas in the West, and it's a very organized program, to the point that they ended up establishing the Islamic Society of North America, which is kind of the graduate program for the Muslim Students Association, and it has become the most important and biggest Islamist movement, Islamist organization in the United States.
Qutb is an interesting figure, Andy. He features prominently in Lawrence Wright's The Looming Terror. He features in your book, The Grand Jihad. Most Americans don't know he became radicalized in Greeley, Colorado, of all places. But he is for violent jihad, and eventually Nasser had him executed when he could not be converted to other than violent jihad. It's a fascinating history, and I see in these protests too much organization for them to be some of them are no doubt spontaneous, but some of them are being paid for by people, and I don't know who, Andy. Do you think anyone's interested in that anymore?
I sure hope they are. There's a great piece in Tablet about that very subject a couple of days ago. I wish I had it in front of me, but I'll send you the link to it. It was on this very topic and very important and very well done, very informative. But I also think, after, I guess I was toward the end of my time, one of the last things that I had to do in the U.S. Attorney's Office was a litigation with Susan Rosenberg from the Weather Underground to keep her in prison. She was trying to get out of her sentence, and it took about a year and a half, but we prevailed, after which Clinton pardoned her. And I've always been interested in her and that whole thread of the radical left, because she ended up, all these people failed upwards, right? Like Bill Ayers goes on the lam with Bernadine Torn for, 10, 11 years, and then they end up having very high-profile jobs in academia, including Ayers had a very big job in designing curricula throughout the country. Rosenberg was going to teach at Hamilton College. That caused some uproar, but to make a long story short, she ended up in a very big job in these deep wells and networks of progressive funding.
People do not. It's an octopus. They talk about the Koch network being the Kochtopus. In fact, the network that people ought to be concerned about is the Islamist network, because it's real and it's vibrant. The terrorist network, the old Red Brigades and the old terror groups like the Weather Underground, they're too old to run away anymore. But the Islamists are young and spry and ready to go. So, Andy, I'm going to move from that to the Stormy Daniels testimony yesterday during the first break, because I want to ask you, we got a young audience in the car on their way to school, so I don't want to talk too much about the intimate details of that. Has it gone off the rails, in your opinion? Just a summary before we go to break.
Well, if you consider that something was already off the rails, however much more it can get off the rails, it really, even the judge yesterday realized he had gone too far, which is saying something.
Well, do you think it's gone far enough that there's no interlocutory appeal here? So I think Trump's going to get convicted. How long will it take to get that before an appeals court?
A year, probably.
Gosh.
Maybe more than that.
So
Harvey Weinstein, that was 3 years, right?
Yeah, but I just cannot believe what they've done in the American political process by a Judge Merchan and Alvin Bragg. Andy, we can talk without worrying about the FCC at this point or about kids being in the car.
Right.
Stormy Daniels is an adult film actress, which means I don't know how she can establish credibility about anything involving intimacy. What do you think of yesterday's testimony? Not whether it should have been allowed, it shouldn't have been allowed, but what she actually said. What is it going to do to the jury to hear those details?
Well, it's appalling. The jury could react to it in a couple of different ways, I think. It could be obviously incensed against Trump, which was the design of it. I mean, it was gratuitously belittling of him, you know, just even taking the sexual aspects of it out and just the personal, the interpersonal dynamics of it. It was meant to cast him as, it was almost a, you know, sort of a left-wing or progressive anti-Trump, Trump deranged caricature of him. You know, he's rude, he's awful, he's loathsome, you know, whatever adjectives you could throw in. And she said that she was experiencing him in real time, the way that he's projected in political commentary, which is just, I think it goes to exactly what this prosecution was designed to do in the first place, which was to be a political hit on Trump. And the main objective of it is to be able to have, even if it gets laughed out of an appeals court, Biden, in the run-up to the 2024 election, will be able to call him a convicted felon. I mean, that's what they want.
Well, they're also, the thing that's astonishing is she suggested that their encounter was non-consensual. And
Yep.
I've never heard that before. The jury heard that. I mean, that is awful that the jury heard that. She can't, how did that happen?
The judge let it happen, Neil. I have to say this is not a new story. You know, she's told the story publicly again and again, and the thought that, like, the judge was taken aback by how graphic and how gruesome it seemed on Trump's part, to the point where he, after letting it in and knowing exactly what it was that he was letting it in, he decided to dress the prosecutors down for doing what he let them do.
Didn't he blame the defense counsel as well? I couldn't believe my ears. They moved to strike the witness beforehand.
Right. Well, they should have struck the witness before. But this is a thread that goes through the whole trial. He says whenever he gets in a corner, he says the jury can figure out, it's up to the jury to decide the witness's credibility. And as you well know, this isn't a criminal law proposition. This is a law proposition.
Yep.
Credibility isn't the only issue. The issue here was the relevance of her testimony and whether the probative value of it, which was negligible, was outweighed, as it easily was, by not only the prejudice to Trump, but the confusion to the jury about what the legal issues was. If this was somebody doing trials for 10 minutes should have been able to figure that out.
I couldn't agree with you more. And the probative value is nil, zero, a minimum. I don't know that it should not have been mistried immediately. They brought the motion for mistrial. That's among the many appealable things. Andy, for the benefit of the audience and you, my one experience on a jury with a 3-strike case of a guy who carjacked 2 cars viciously, drove them the wrong way on interstates, ended up in a crack house, wouldn't come out. I mean, a long series of charges. We ended up in a hung jury after 2.5 weeks because one juror was the spouse of a public defender and there was no way he was going to vote to convict. So he refused to accept DNA evidence. There was no basis. The prosecutor mailed it in and didn't establish the evidentiary probity of fingerprint. But I saw firsthand for 2.5 weeks, I'd been cautioned by the judge because I didn't want to be on this jury. I said to him, Judge, I was a prosecutor in the Department of Justice, which may have stretched the truth a little bit since I prosecuted warrants in the Foreign Intelligence Surveillance Act, but not people. And I just did not want to be on the jury, but I was, and he cautioned me not to take it over, so I didn't say much. But Andy, they're crazy. They're absolutely crazy things. So what do you think is going on in the heads of these jurors right now in New York?
That's a great point, Hugh, and it's a great question to raise because I find myself, especially in our coverage on Fox, having to not only remind viewers, but remind myself of this. The jury is not getting, John Hugh or John Turley or me or, any of we have a number of wonderful people on Fox who would do an analysis of this case. They don't get that like every half hour they get a break and then the lawyer can tell them what's going on and what's wrong with it or what's right with it, et cetera. Juries, in my view, after dealing with them for a long time, in criminal cases, I think they take their cues from the judge. And the unseen dynamic to me that's always been most important in a criminal trial is how the judge interacts with the government lawyers. And if the judge smells a rat and doesn't like the case, the jury knows that. On the other hand, if the judge trusts the prosecutor and the prosecutor looks like the prosecutor's playing it straight, then that's very powerfully influential over the jury. I don't mean to say that what the defense lawyers do is irrelevant, because it's not, but I think most cases are not won by flashy lawyering or even just like good, solid lawyering. Most cases are decided by evidence and a straightforward application of what the law is. The unusual thing in this case is that to the extent there's mountainous evidence, it is evidence of lawful conduct. It's not hard for prosecutors to look like they're methodically building a case if what they're proving is something that doesn't break the law. It's not hard to assemble evidence about that. And the most important thing in this case, which is the thing we have no read on yet, and I think we really should, is by now both sides should have submitted to the judge what we call requests to charge, which is the proposed jury instructions for the end of the case. It's really essential to know what it is that Judge Juan Merchan, who's presiding here, is going to tell the jury about the essential elements of the crime, particularly the mystery crime that Trump is supposedly falsifying his business records to commit or conceal, which here we are in the third week of trial and nobody has a solid read on what that is yet.
Now, Andy, I mentioned my experience on a jury because there are two lawyers on this jury. And if Trump has any chance of a hung jury, I'm reposing it in those two lawyers who may be able to smell a rat. And in the way I just was astonished by what went on in my jury room. What do you think about two lawyers on this case? Will they be able to suss out that this is a railroad job?
It really depends on the lawyers. I wouldn't make a categorical assumption about lawyers. I mean, look, if you're going to talk about Manhattan lawyers, which is what these people are, they could be very discriminating lawyers who will see the problems with the state's case, which are immense, or they could be the kind of lawyers who were lined up from Fifth Avenue to Guantanamo Bay to represent the jihad. I don't know which ones they are. So, and they could also be lawyers who, if this was a real estate transaction, instead of a criminal case, I'd be at sea. Yes, I'm a lawyer, but I might as well be, a cobbler for all I know about real estate.
Yeah, the only time I ever argued in front of the Ninth Circuit, I argued an endangered species case that the poor judges who included Stephen Reinhart and a couple of other very experienced judges from the left, they had no idea what we were talking about. And they've been doing their job forever because ESA work is really weird. Andrew McCarthy, his book, The Grand Jihad, is fascinating reading if you want to know what's going on campuses, even though he wrote it, 15 years ago, Andy. It's the first time I ever met Andy was talking about that book, and it's still so relevant. But more importantly, you want to go get the McCarthy Report at wherever you get your podcast, follow it, rate it with a 5, and be smart about these cases. Andy, I got to talk to you about not letting Brad Smith testify. I don't know much about experts. I got a lot of tort lawyer colleagues that were my partners when I practiced law. I'm retired now. And they knew about experts, and we talked about experts all the time. I cannot imagine not letting Brad Smith testify as to the unique nature of the prosecution's claim. What is going on? Brad Smith, former FEC chairman, law professor, expert of experts, and what has the judge done to him? He's gagged him, hasn't he?
Well, he's gagged him in the sense that he won't let him testify about the thing you would want him to testify about, which is if the prosecution is going to claim that Trump was concealing a campaign finance violation, you need to have someone who can explain campaign finance law. Now, Bragg shouldn't be in that position because he doesn't have any authority to enforce federal law. But since he's trying to sneak it into the case this way, you ought to have, the whole reason that we have an FEC, is to make sure that we have uniform application of the campaign laws throughout the United States. So to have a state district attorney basically, invoke these laws and make up the law as he goes along, which is not consistent with how the Justice Department and the FEC enforce it, is a really bad thing. It's counter what Congress had in mind when they established these laws in the first place. And here, it's even worse because while the judge is not allowing Brad Smith to explain the law, he has allowed evidence from David Pecker, who was obviously not an expert in this area, who testified that he was fearful that he was in violation of the campaign laws, and that's why they signed a non-prosecution agreement with the Justice Department, and why the American Media, Inc. Ended up paying a $180,000 fine to the FEC. And he's also allowing Michael Cohen to tell the jury that he pled guilty to 2 campaign finance charges under circumstances where it's black letter criminal law that one conspirator's guilty plea is not admissible to prove the guilt of another conspirator. In other words, Cohen's guilty plea should not be in front of the jury because they could be confused into thinking that because he pled guilty, that Trump must be guilty. So it's exactly the kind of evidence that's not supposed to come into the case. If he's going to allow Cohen and Pecker to instruct the jury about campaign law, then he ought to allow Trump to put somebody on who knows something about it, which is exactly what Brad Smith would add to the case.
I thought your discussion with Rich about his refusal to allow Smith in and his failure to specify the indictment is the most plain-spoken argument made. Are Trump's counsel allowed to make these arguments in closing argument? Andy, can they say, we weren't allowed to put in Brad Smith, Stormy Daniels went off the rail, Michael Cohen's plea shouldn't have been allowed in, we're going to challenge all that on appeal? Can they say that in closing argument?
Ordinarily, a judge would not let lawyers make legal arguments to the jury in summation if they depart from, you're supposed to have the jury charge before summation so you know what the judge is going to tell the jury about the law. And if you're, in a trial, if you know you're going to make an argument to the jury and the judge is going to sustain an objection, that makes you look bad in front of the jury. So you don't want to be making arguments that the judge is going to sustain objections to. The idea is to preserve all those objections on the record at the charge conference, but I don't think they'll be able to make those arguments to the jury.
That is unfortunate because I do think a good closing argument here would kill this case, even with a blue jury, but I don't think he's going to get to make it. Andrew McCarthy can be followed on X at Andrew C. McCarthy. You can get the Grand Jihad, his book that I mentioned earlier, at Amazon, and you can follow the McCarthy Report and be smart about this, or you can watch a lot of cable and be stupid. I got to play for you one cut from cable. I like Casey Hunt. She's very smart. Jake Tapper is the second voice. I don't know who the third person is talking here, but listen to Jake's injection to Casey's comment, Andy. Cut number 26.
Jurors, Casey?
Just one thing that I've been sort of noticing as this has gone on is that there have been a couple times where she seems to be cracking a joke, trying to get a reaction from the jury, and our reporters in the room have noted that the jury hasn't seemed to respond to that.
No, they're taking their job seriously.
I mean, what do you make of that?
Humor is risky in the courtroom.
All right, stop right there. So, Andy, Jake has not been in the courtroom. Casey has not been in the courtroom. The third person hasn't been in the courtroom. They're talking about the jury not laughing. That can't be good analysis. I mean, it just can't be, is it?
Well, I mean, you don't know what the context is, so I don't want to be critical of them. Maybe there was something that was very telling that they didn't laugh at. I wasn't in the courtroom either, right? So I think reading the jury view is a very important thing. People who are reporting from the courtroom are in a much better position to tell people about what's actually going on in there than those of us who aren't inside. And there's a reason why appellate courts don't reverse district judges or trial judges on evidentiary calls and credibility calls, precisely because they respect the fact that the trial judge was in the room and they weren't, and they're going off a cold record. So you know how that goes. I don't want to blast.
Yeah, well, but the comment I didn't like, Casey's making a comment. She wasn't there. Jake says, well, they're being serious about their job. I'm sorry, you have no predicate for making that statement. Just what you just said. Neither you nor I nor Jake nor Casey nor anybody else who isn't in that courtroom can say anything about the jury, and even the people in the courtroom. They have no idea how crazy the criminal jury system is. It's not 12 angry men. It's a roller coaster. It's nuts. All right, Andy, let's get to the ruling in the documents case. As expected, we're not going to trial this year. I am the least surprised journalist in America. What do you say?
Well, I think you and I talked about this after the indictment and did a long interview, if I'm remembering you, about
You are.
FIFA.
Yep.
And we said at the time the chances that this case goes to trial before the election is remote at best. And I think it's just played out the way that you would expect if you've ever seen CIPA litigation before. I can't imagine why. Well, I can't imagine because it's so political, but there's a lot of criticism in the last 24 hours of Judge Cannon. And I think if you look at her order, it looks to me like she's trying to keep a handle on this thing and not let it get off the rails, which a CIPA litigation really can. She's holding their feet to the fire. She's setting up, all kinds of benchmarks in terms of the scheduling for stuff she wants to get done. And she's had respect for something that neither the government lawyers nor the media have had any respect for, which is that Trump has a right to be in attendance at a lot of this stuff, which he can't be because they've orchestrated 4 different trials of him, 4 different indictments in a very compressed period of time.
So that's done for this year. The former president has been my guest a lot of times. One of the few questions he's never answered, I asked him directly before any of this got going, did you instruct anyone to move the boxes? And he said, I don't have to answer that question. I'm not going to. I respect that. And since then, I've agreed with his lawyers that when he comes on, I'm not going to ask about the case because I don't want to send someone to jail, which leads me to this question. Would you let Trump testify anywhere, anytime under oath if you didn't have to?
Not if I didn't have to.
Exactly.
But we should tell people that there's about 2 big decisions in every case that only the defendant can make: whether to plead guilty and whether to testify. The lawyer can make pretty much every other call, but those calls belong to the defendant. The lawyer can give the best advice he can give, but at the end of the day, it's going to be Trump's call.
You know, I've interviewed the former president a couple of dozen times, and I would never put him on the stand because I never know what he's going to say to any question. That's what makes him the best interview in America, why everyone would have him on tomorrow if he would sit for him, because you never know what he's going to say. It's great for the audience. It's great ratings. I would not want, I've been prepared for a deposition before. You got to stay in the lane, Andrew. Have you ever lost a witness going out of the lane?
Yeah, but, I've never had a witness who, like Trump, talks all day. And he'd be very hard to put on the stand, Hugh. He'd also be very hard to cross-examine. So he's not a picnic either way. And I've heard your interviews with him, which have been great, but I would not want to have him as somebody who had a break on cross-examination.
Absolutely not. And
his opposition doesn't want to acknowledge this, but he can be a very charming, disarming guy, and a jury might end up liking him.
Oh, he's got charisma, but I'm afraid of 18 U.S.C. 1001. I'm afraid that whatever he says under oath will come back against him for a False Statements Act. So I would never let him near a prosecutor. So let's quickly run down the D.C. case, the Georgia case, and the Arizona case, Andy. We got about 4 minutes here. What do you see happening in those forums? I don't see anything happening because of the Supreme Court case.
I think the D.C. case is the only one that has a chance to go to trial, and it would depend on Jack Smith doing something that is very out of character from anything we've seen up until now. I thought, Liu, in the Supreme Court argument on immunity that John Sauer, Trump's lawyer, gave a lot of ground in terms of saying that there's a lot of information in the indictment that's private conduct that is not amenable of an immunity claim. If Smith really wants to get to trial, I think the Supreme Court's going to remand the case to Judge Chutkan to sort out what's private behavior and what's possibly immunized official executive behavior. Smith could short-circuit that by saying, you know what, here's what they've conceded is private. Let's just go to trial on what's private.
Andy, you're right. Now, the counsel, there is one other big deal I want to get to. Counsel for Jack Smith and DOJ, Mr. Dreeben, excellent advocate, as was Mr. Sauer, made a point of saying repeatedly the former presidents are protected by the processes of the Department of Justice. Put that aside. Amy Coney Barrett, Justice Barrett, at the end brought up state prosecutors. And I think she seemed to intimate, we got to have a rule against state prosecutions of former presidents for acts, whether they're official or not official. Did that appeal? Did you hear that? I heard that very clearly, that she's got a lot of skepticism about local prosecutors and former presidents. And she's right to have that skepticism because it's a magnet for every headline hog in America who's been elected DA somewhere.
Yeah, that's right. I think Dreeben, if I'm remembering right, tried to make the point that there would be a supremacy clause issue.
Yes.
If you had state prosecutors go off the rails and do politicized prosecutions. But the thing I reject about his position is it seemed to me, I know Mike Dreeben and a bit, and he's a very smart guy. I agree, but to look the court in the eye and say, you don't need to worry about politicized prosecutions because we have all these prosecutors take oaths, there are grand juries, we have all these safeguards. And as he's uttering those words, Trump, who has a right to be present in the Supreme Court argument on immunity, which is a pretrial issue, he's got a right to be present for that. He can't be present because he's up in New York on trial in the most blatantly politicized prosecution that anyone's ever seen. So even as his rights are being blatantly, unabashedly violated by both the federal and state processes, Dreeben is looking the court in the eye and saying that kind of stuff doesn't happen.
Oh, that hadn't occurred to me, Andy. You're absolutely right. If we had a split screen, of course, the Chief Justice and some of the members of the court will be very aware of that, right? I'm banking on this court to come down with a very serious decision that parses official acts from private conduct and has an evidentiary process for Judge Chutkan to follow. And I don't think it's going to get to trial either. If they do that and Smith doesn't. So last question. Do you think this is the last Trump case coming this year?
If Smith acts in Washington the way he's acted in Florida, where I think in Florida he could also have gotten to trial quickly if he had just slimmed that down to an obstruction case rather than the ridiculous 36 classified information felony counts that Biden isn't looking at, but Trump is. If you just made it an obstruction case, he could have gotten to trial. And the only way he could get to trial in Washington is if he's willing to slim it down to what he knows is private. And that's just not who he is. I think he's going to say, I want my whole case, and I don't think he has immunity. And that's going to mean he's not going to get to trial, which is fine with me because he's a prosecutor. He shouldn't be conscious of the election calendar. It's outrageous that he is.
It's also fine with me because Trump is the nominee, and we are 5 months away from voting. Last word, Andy. 5 months away from voting, and he can't campaign 4 days a week. Isn't that troubling?
It's outrageous that these judges think that the administration of justice in their little trials is more important than the American people's interest in having, a full, fair debate in a presidential election.
Well said. I'm going to leave it there. Andrew, thank you for joining me. Follow him on X at Andrew C. McCarthy. Go and subscribe to the McCarthy Report. And I'm going to urge Rich Lowry to do more work and get Andy to do more work, because this is a time when we need serious analysts, and Andy's one of them, and Rich is a great host, and he needs to be out there more. And I appreciate the time, Andy, a lot. Thank you.
Thanks so much, Hugh. I appreciate it. Thank you.